Okay, but that doesn't happen here.
So,
That's a motion for downtown. That's a motion for downtown. Today, all they have to do is give me reason to believe that on August 10, 2000.
Welcome to Bench Scope USA.
Mr. Jadala, what do you got?
wrong.
BRU? I've got it.
There's developments showing you're not getting from. On the 11, the 11, stuff for their be between the children. I hope to gain weeks. Coachman, the told me they saw her walk out to ensure that all these have callers, she could identify him and put them around. He can dismiss, there's no reason why it's from.
Okay. All right, we'll issue a bench warrant. No problem. Mr. Hadley, I'm ready on Woods. Thank you.
Where does the bridge to the discovery is the proceedings estimated?
Yeah, would you waive formal reading?
You go forward, you can see the effect your answer PR bonds, manual safety issue about no alcohol or drug use, $11 should sign.
All right. Are you working, Mr. Woods? Where do you work and how long have you been employed there?
I'm working at the Oakley Fire Department, as a leasing agent.
Yep.
I'm working now.
Okay. Where'd you work before that?
As a science salesman, and, science one and, I was, a receptionist slash, sales consultant.
Okay.
Well, Steve stated the allegations they don't make, my client has a very proactive situation. He's been refraining from the alcohol.
Good.
Actually, actively drinking, false.
Good. Beautiful.
Just want to let the board know.
Beautiful. Beautiful. Yeah, get ahead of the game. All right, Mr. Woods, court dates can be 12/3, 9:30, all right? 10 a.m. And I'm gonna put you on a personal bond. First two conditions are pretty obvious. Number one, stay out of trouble. Number two, be in court. Third condition, do not purchase, possess, or consume any mood-altering substance unless you've got a doctor's prescription. That rules out alcohol and marijuana. You can live with those rules? Raise your right hand. Swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you screw that up. Any questions? Just have a seat till we get your notice.
Thank you for speaking, sir.
Give me a name on the exam.
Jones.
Jones. Waiver? All right. Your appearance, counsel.
Good afternoon, I'm Anita with the Service of Insurance. Jones, who is against arrest. You know, please state.
There you go.
Thank you, Mr. Jones. Go ahead, counsel.
Examination, it's not understanding that they want to proceed with that.
Right.
We are, I have advised that you don't please break, but you're going to the clear front right, you wish to see what
Good. All right, Mr. Jones, is that true? You understand your rights? Okay, but you understand that you've got a right to a trial. You understand you have different kinds of trials are available. You've got an attorney to advise you. You understand all that? Right. And you understand the purpose for the exam? Sure. If we hold an exam, the prosecutor has to prove two things. One, that a crime was likely to have happened, and two, that you were likely involved in that crime. It's a probable cause burden. It's not a beyond a reasonable doubt. Okay? So it's basically reason to believe. You understand that? If I answer both those questions at the end of the exam with, yeah, there's reason to believe, I'm going to send it downtown. By waiving, you're just saying, let's just go downtown and deal with it there. You understand that? That's all I've got is one count, carrying concealed weapon from October 10th, or excuse me, August 10th. Okay, but that doesn't happen here. That's a motion for downtown. That's a motion for downtown. Today, all they have to do is give me reason to believe that on August 10, 2025, you had a weapon and you weren't carrying it legally. It was concealed weapon. That's all they have to do. You understand that? And you understand by waiving, you're just saying you're not going to make them do that. You're going to make them go downtown and prove their whole case. All right. Does anybody disagree with the way I explained the process? You want to clarify anything? Okay. So understanding that, are you waiving today? All right. And you're doing that because you think you're taking her advice that it's the best thing for you to do? Okay. All right. So I will accept the waiver. You satisfied that it's knowingly, voluntarily made?
Yes.
All right. So I'll accept your waiver. Your next court date is going to be next Wednesday, 9 a.m. downtown. Understood? All right. Anything as to bond? Let me figure out what it is first and make sure we're all on the same page. It looks like it's a 10,000. No, that's PR.
The court includes that. Recently.
Do you know when that was?
The 15th.
Oh, here we go. Here we go. I still can't find anything for
That comes about as based on okay.
conditions.
Judge not possess any weapons, firearms, or ammunition.
Oh, okay. Yeah, this is the one we got the report in. Yeah, we got it. We got an incident report that said that he was involved in some other incident on October 8th, and that there were firearms involved. Okay. All right. So now I think we're on the same page what the bond is now.
Yes.
All right, go ahead.
Your Honor, I would to consider a reduction to a personal bond for arrest because Mr. Jones, obviously he's in a wheelchair, so
Mhm.
was shot.
Yep.
He is receiving some treatment in jail, but not to the extent that he should be. He's supposed to be enjoying physical therapy, but he will just walk in.
Mhm.
That's not how. I understand, that the people are going to talk about other things that could potentially rise. At this point in time, it's the job of charge of getting and other than the speech that we are so important. So I would ask the court to consider a personal bond of house arrest so that he can still get his physical therapy.
Right.
And give back the freedom that he needs. He does have a place to live with his girlfriend's mother, who indicated that he can stay with her. There were other things he could have, like given favors and whatnot.
Right. Right. Okay.
So I am asking the court to consider that reduction in those.
Okay.
The front also correct that there is another pending case.
Out of the October 8 incident.
The hearing got in charge at this time, 11 p.m. is currently being investigated by the police during the arrest and the shooting. Originally, time that the alleged incident occurred, the defendant was under the court's bond conditions, which prohibited them from being in possession of any weapons. As you know, Your Honor, the court speaks to its orders, and the defendant clearly disregarded that. So based on that, I'm going to request $100,000 cash, no sentences from these individuals.
I understand.
In regards to the rifle file, we have no objection to the court labeling the file with indivisible.
Go ahead, Ms. Castle.
I don't know if you given any new facts that the court was not made aware of that. I will formate that decision. But I am asking the court to consider the personal bond, giving the health conditions that my client has. Also, my understanding, the other legal involved to run the past super deeply on the conflict. fact that my client has not had it.
Yeah.
Is having, so I have to consider that as well. I also building earlier that he does have support in program, his grandmother, excluding half. His girlfriend is here. His girlfriend's father was here but had to leave. And, Reverend Robert Olive is here. He is, going to be mentoring him.
Good.
Just, Detroit. But
Right.
he's-
Okay. Thank you. All right. So while you two were both talking, I found my notes. I'm the one that increased the bond to 20,000, 10%. And this is going to come off snarky. And I'm not trying to be snarky or sarcastic, but had he followed my bond condition, he wouldn't have been in a shootout and be in a wheelchair right now. He can't follow bond conditions. I'm not going to let him out on a personal bond again. So I'm going to leave the bond exactly as it was when I set it on October 14th. It's 20,000, 10%. Good luck downtown.